Thank you. Konnichiwa, kokoni korete oreshides. Thank you for having me. I want to present some information on the GDPR. I'm sure everybody of you knows about it, the data protection law in Europe, and also give you some information on the new Japanese data protection law, and also have a look on international data protection laws. So, I mainly want to focus on three different issues. This is the definition of personal data, personal information, and PII. I think when talking about data protection in an international perspective, it's difficult to know what law requires what information, because the terms are used differently in all countries. So I want to give some short information on that. Then I want to give some information when the GDPR will be applicable, and also some information when it will not be applicable, so how you can avoid to have the GDPR applicability in Japan or in other countries. And at the end, I want to give some information on IT security. As short words on me, I'm a lawyer since nearly 10 years. I'm advising in data protection since I started working as a lawyer. And I started to advise on the GDPR when the text was published. So I'm happy to give some information to you in Japan. So let's take a short look back to the 25th of May 2018. The GDPR became applicable, and if you read German or European newspapers, you thought the world was going to end. All business had to close down because the new provisions were impossible to comply to. If you wanted to look at, for example, American newspapers, then you saw some signs like this one from the Los Angeles Times. You simply couldn't read it anymore because they were blocking all European users from accessing the website because they were afraid of the GDPR. Other websites are now using plain text versions for European users, and also, for example, USA Today has a European Union experience, meaning no pictures, no advertisements, no tracking. And so on an international level, it's still unclear how to comply with the GDPR, what the regulations are. And judging from the information you could read on newspapers, you could think the GDPR would harm European businesses, and no other country in the world would follow. But if we take a look at other countries, I just wrote down some examples. Korea is thinking about updating the Personal Information Protection Act. India is preparing a protection bill. China had a security law in 2017, which also had some information on or some guidelines on data protection. And I guess most notably in California, the California Consumer Privacy Act will be valid from 2020 and will have a strong new regulation for Californian companies. So you could think the GDPR maybe started a movement or will become a success. And looking at Japan, there were two new trade deals concluded between Japan and the EU in January this year. It was the biggest trade agreement concluded to date by the EU. And this trade agreement not also had regulations or information on the simple economic and strategic partnerships, but also clauses on labor rights, environmental protection, intellectual property, and also data protection. So on the 31st, on 23rd January 2019, both in Japan and in European Union, there was an adequacy decision stating that each of the countries of the areas have the same level of protection. And I want to go into detail on these informations on future. And you might wonder, how did Japan manage to get this adequacy decision based on the high GDPR level? Well, of course, by new data protection laws, by pretty strong data protection laws. First, the Act on the Protection of Personal Information, APPI, which is the basis for data protection in Japan. And you can compare it to the GDPR. And it has some further documents like the cabinet decision and the enforcement rules, which are also a valid law for all companies active in Japan. These three provisions are applicable for all Japanese companies, while the fourth, I wrote down here, the supplementary rules, they are only applicable in case personal data was transferred from the EU to Japan, and then these additional supplementary rules will apply to Japanese companies. So first, looking to the different definitions of personal data, personal information, and a quick view on the PII. There are many different terms how types of data are described. I wrote down here just a few of the important terms, and I want to focus on three terms. So it's personal data, which we are talking about in the EU, personal information, which is used by the APPI, and to have a look at the personally identifiable data in the USA. So when looking at the definitions of these three terms, we can see that they are nearly the same, the definition. So the APPI says any information relating to a living individual. The GDPR says all information relating to an identified or identifiable living natural person, and even the definition of PII here by the NIST is saying any information about an individual maintained by an agency. So when looking at these definitions, you could think it's basically all the same, but it isn't. Why is that? Mostly because of the interpretation or the definition of pseudonymous data or personal information. If data is pseudonymized, if identifiable characteristics are replaced by identifiers, then, according to the GDPR, and as is my understanding also according to the APPI, this data is still considered personal data. So even if you have lists with some identifiers not stating the name, the GDPR considers this personal information. Also, encrypted data is still considered personal information, and so the data protection rules will apply. And the controller itself doesn't need to have access to this data or to the identifying information, even if some other controller only has the key to identify the person, then still it is considered personal data. Looking at some examples, I want to start with PASMO. I got it when I was here in Japan the first time. So for you not familiar with PASMO, it's an IZ card and it helps you to use the metro, to use cabs, and you can pay without cash nearly everywhere. So it's really practical, and you can get PASMO or other IC cards without stating your name. You just have to pay a short amount, and then you will get the PASMO at the vending machine. But it has a number printed on it. So, of course, every IZ card has an individual number, but it is not directly related to one special person. And still, the GDPR considers this to be personal information. This is personal data already, and this is different regarding the term of PII in the USA. So let's look at some more examples like name, address, date of birth, social security number, credit card number, an email address, and not stating a name, Superman42, for example, at hotmail.com. It's not my email address. Just as an example, in all countries or under all definitions, this would be considered personal data. But if we look at IP addresses, device IDs, especially regarding IoT, for example, or online identifiers, location data. Under PII, this won't mostly be classified as PII. Looking at personal information, the term in Japan, we can say most of it will be considered personal information, even things like device IDs, online identifiers, because the definition of the Japanese Data Protection Act is really close to the APPI. Still, I put some brackets on it because the discussion in the next years will show whether this all will be considered personal data. And looking at the GDPR, you know the answer already. Everything of that is considered personal data. So even IP addresses, device IDs, all such technical information and information which is necessary on a technical basis, this is considered personal data, and therefore the GDPR will apply. So next, I want to talk about the question when the GDPR and also the APPI will apply in the different countries. So in some cases, of course, just because you are processing personal data in one country doesn't mean you have to relate to the GDPR. And I want to present three different cases. So the first case is pretty easy. I just took the European and Japanese flags as examples, but these basic provisions you can use them and apply them pretty everywhere. So if there is a data of a data subject who might be located in the EU or in Brazil or in Japan, and her or his data is processed by a company in that country, then of course only the data protection laws of these countries apply. The next step will be if the data is collected by a company in the same country as the data subjects, but afterwards the data is transferred to another country. This of course happens many times, just when using US service providers, then the personal data will be transferred. And the third case I want to talk about is when personal data by data subject is collected in the EU directly from Japan, or also here directly from another country like the USA, because in this case, again, other legal requirements will apply. Looking at the first case, basically a collection of a data subject's personal data by an entity located within the same country as the data subject, then the data subjects and the entities' local laws will apply. This is pretty easy, and so it will be more interesting to talk about the two other possibilities. Just one hint that the GDPR has some special provisions which were disclosed by the European Court of Justice, who said that the territorial scope might also be applicable if the foreign country has an establishment in Europe. So if this establishment in Europe does not process the data subject's personal data, the data might be processed directly from Japan, might be collected in the EU, but directly transferred to Japan. And there's just some entity doing advertisement, for example, then this might lead already to GDPR applicability. But this is a special case, and I want to talk about the two other more practical cases, which for every company are relevant on a daily basis. So this second possibility is that data is collected of a data subject within the EU. A company located in the EU is processing that data, and afterwards is transferring that data to Japan. Then we will need to take a look at two steps. The first step, of course, the company located in the European Union needs to comply with the GDPR. On the second step, also the transfer from the EU entity to the entity in the third country needs to be covered by GDPR. And such third country transfers, the GDPR states several rules. It's pretty much the same with the APPI. I will explain that afterwards. The GDPR basically says that for full GDPR compliance, the first entity in Europe needs to fulfill all of the GDPR's requirements, and this includes appropriate safeguards. So this adequacy decision, which took place on Japan, this is one of the adequate safeguards. Others are the standard contractual clauses. I'm sure many of you heard about it already, or safe harbor many years ago. And now it's the privacy shield for data transfers to the US. Or binding corporate rules are another possibility of these appropriate safeguards to transfer personal data from the European Union, from an entity located in the EU to an entity located in a third country, for example, Japan. And this, of course, applies no matter whether the processing takes place within a group or takes place just with service providers or with other companies. So the receiving entity will be bound to the provisions of the local laws. So, of course, a Japanese company receiving data from Europe will have to comply with the APPI. But still, again, in addition, the appropriate safeguards required by the EU or by the GDPR also have to be complied with. So, for example, if standard contractual clauses are committed between the two entities, then also the receiving entity in Japan needs to fulfill these contractual binding rules. The adequacy decision will help to not to use standard contractual clauses. It will make things easier. I will go into detail shortly. But looking into Japan, the APPI also has some requirements on third country transfers. And it basically states that if the Personal Information Protection Commission has some adequate safeguards for transferring data to one country, if it was decided that the other country has equivalent standards, then the data can be transferred without further notice. Or you can do contractual agreements between the Japanese entity and the entity receiving the data. Or another possibility is to obtain consent from the data subject. And this also, it is my understanding, it also applies within Japanese groups. So, for example, if you export data of your employees from the Japanese entity to an entity based in another country, then the APPI states that you need to fulfill these further appropriate safeguards. So looking at the third case, now, because when looking at the second case, you might have thought it's a bit difficult, too many rules to comply with, so you will just directly collect personal information from Japan, and even if the data subjects are located on an international level, then if you process and collect the data from Japan, you might not need to comply with the GDPR. But unfortunately, that isn't true. So when we look at the case of a collection of a data subject's personal data by any entity located in another country than the data subject itself, speaking in a general way, it doesn't only have to be the case in EU and Japan, then the local laws of the collecting entity, of course, will apply. But most data protection laws also have an extraterritorial scope. So if you collect data directly from another country, then this might mean that the legal obligations of the country where you collect the data from will be fully applicable. And this is not only an idea which the GDPR uses, but it's also an idea the APPI uses, and also the CCPA in California. So the CCPA also has such extraterritorial scope. So if you are doing business in California, you also need to look at the CCPA to ensure that you will be compliant with that. So I want to go into detail on the question what the GDPR states on this extraterritorial applicability. So if you are a Japanese company collecting the data directly within the EU of data subjects located there, then there are two possibilities when the full GDPR will apply. One possibility is that you offer goods or services in the EU from Japan, or the other possibility is that you are observing the behavior of data subjects located in the EU. So looking at the first possibility, offering goods or services in the EU, this is, for example, if you have a web shop and this web shop is also available in German, in French and Italian, and payments can be made in euro, then the GDPR will apply for all the data which is collected by the data subjects within the EU. The other possibility is observing the behavior of data subjects located in the EU. This is basically linked to every activity linked with behavioral monitoring of data subjects. So basically, if you use cookies, if you use online tracking, advertisement tracking on your Japanese website, and you have visitors from the EU, then the GDPR expects you to comply with the GDPR for all of the data you collect from the EU. So this is a pretty difficult task to fulfill because, of course, it's hard to avoid that some European data subjects might visit your website. And this observing the behavior of data subjects located in the EU might also be a problem regarding IT security. So if you do intelligence, if you do a scanning of possible threats, then of course you might collect personal data just to check on possible threats. But still, if you are collecting that data outside of Europe, then this might mean that the GDPR will be applicable for that. The GDPR has further provisions in case this extraterritorial scope applies. For example, probably the most important one is that you have to designate a representative within the EU. So if you are located only in Japan, but you are doing business in Europe, then it might be necessary to designate a representative within the EU who will help you with EU regulations, but will also forward, for example, requests from data subjects or requests from data protection authorities. And Article 31 also states that you have an obligation to cooperate with the supervisory authority. Here, of course, there's the question if that will work out or what the supervisory authorities will be able to do in case you don't want to cooperate. And on an international level, of course, European data protection authorities could try to get in contact with the Japanese data protection authority, but this will be a pretty long process. So on a practical basis, even if you are supposed to comply with the GDPR, maybe there is no possibility for supervisory authorities to really get you to comply with the GDPR. So looking again at the three cases and summarizing the different cases. The first is pretty easy. If a data subject is located in the EU and the data is processed by an EU entity, there is no international relation, then of course only the local law will apply and no Japanese law will apply. While in the second case, the data subject is located in the EU, the data is collected by an entity within the EU and then transferred to a Japanese company, which will be the case in many groups and in many cases. Then in Japan, of course, the local Japanese law applies, which is the APPI, the basic policy, the supplementary rules. They always apply for Japanese companies. And in addition, the Japanese enforcement rules will apply. And some GDPR purpose limitation. So basically, you are only allowed to process the personal data for the purposes which were set by the entity in Europe. And of course, if there is other parts of the adequacy decision, for example, if we are talking about US data transfers and you are relying on the privacy shield, then you, instead of the enforcement rules, you need to comply with the privacy shield. If you use the standard contractual clauses, you will need to comply with the basic rules stated within the contractual clauses. But looking at Japan, thanks to the adequacy decision, the most important thing will be to rely, of course, on Japanese law and in addition to this enforcement rules. And looking at the third possibility, when data is collected directly from to Japan from the EU, then in Japan, of course, the APPI basic policy supplementary rules will apply because it's Japanese law. But in addition, in this third case, the whole GDPR will apply. So actually, it might be a good thing to try to use more of the second possibilities, and this might give you some more flexibility within the company because in the second case, there's not the full GDPR applicability, while in the third case, the GDPR will apply fully. So you might think of transferring personal data from the EU from a company located in the EU and then transferring it. So for the third and last part, I want to give you some information on IT security in GDPR and APPI. I printed out here most of the compliance obligations which the GDPR has included. I won't go into detail on all these obligations because then we would need a third day for Code Blue tomorrow. And I just want to focus on the security of processing and these provisions as stated in the GDPR. But before that, since we had some interesting talks yesterday on supply chain attacks, I want to point out the question of the contract data processing. So contracts you have to conclude with service providers in case these service providers are processing data on behalf of you. Then Article 28 states that you have to conclude such a data processing agreement. And when talking about supply chain attacks and the question of trusting your service provider or maybe not trusting your service provider, the GDPR and this contract data processing might actually help to ensure trust in your providers. For example, because you have several audit obligations and audit possibilities. So you are, if a contract data processing agreement is concluded, you are allowed to audit the processor, and so this might help to give you more information. And also other of these compliance obligations might actually help regarding such threats to the supply chain. For example, notification of personal data breaches. You have 72 hours in case of a data breach, like a hacking attack or the loss of personal data. And also the service providers are required to inform the controller whom the data belongs to within 72 hours. So this is also a provision which could help regarding such security threats. But I want to focus on the provisions on security of processing and compare the provisions between GDPR and APPI. So the GDPR in Article 32 states pretty broad range of technical and organizational measures which every company has to fulfill. And in Article 32, paragraph 1, the GDPR says that such measures are pseudonymization, encryption of personal data, the ongoing confidentiality, ensuring the integrity, ensuring the availability, ensuring the resilience of processing systems. Furthermore, you need to have the ability to restore the availability in a case of a security incident. And also you are required to have a process for regularly testing, assessing and evaluating the effectiveness of the taken measures. So the GDPR states a broad range of obligations to fulfill. And after all the interesting speeches I heard in the last 1.5 days, it seems like a pretty good thing to have all those regulations, because so business are actually required to relate to such possible incidents. And the GDPR furthermore states that costs and risks are to be taken account. Basically, as a medium-sized companies, you don't have to comply with all the same security rules as a large company, as a large group. But even though the GDPR states that costs are one relevant factor, they are just one relevant factor. And the more relevant factor is, of course, the risks. So even if you are a small company, but for example, you process biometric data, then the risk is higher, and then you are required to have stronger technical and organizational measures in place. So I think this is pretty interesting and well done by the GDPR, because it's not only regarding the possible loss of data, but regarding technical organizational measures, the GDPR has a full approach, also stressing the availability of data. In the APPI and in other countries, it's mostly more limited. So the APPI states in Article 20 that a personal information handling business operator, so the same as a controller in Europe, shall take necessary and appropriate action for the security control of personal data. So this, of course, also is a general obligation to ensure IT security. But the APPI continues that including the prevention of leakage, loss, or damage of its handled personal data. So the APPI stresses that IT security measures are supposed to mostly prevent leakage and loss of data, but still it says that all necessary appropriate action needs to be taken. The APPI stresses minimizing risks of data loss, even though it is not the only requirement. And I think this difference is pretty important in an international context. When I'm checking data processing agreements, I see many providers, especially US providers, who are binding themselves to appropriate technical organizational measures only regarding to ensuring preventing leakage, loss, or damage to personal data. But this is too short. So if the GDPR is applicable, it's not sufficient just to say we will have appropriate measures in place to avoid the loss of data, but it is also necessary to ensure the ongoing availability of the data. So this is one point which should be checked in contracts regarding to the GDPR. Coming to an end, just some short information what the GDPR requires or what is recommended under the GDPR to document IT security measures. So I guess many of you know the accountability principle, which states that you need to prove that you comply with data protection law. This, of course, leads to quite a lot of bureaucracy. And it helps the data protection authorities to easily identify potential breaches of the GDPR. Still, this principle is a common sense within the GDPR, and in some way you need to rely to Article 5, Paragraph 2 and Article 24 of the GDPR, and therefore, of course, also IT security measures need to be documented. And so my recommendation is to have at least a two-step documentation of the IT security measures. I guess most of you in your companies will have that anyways. But I want to stress that having a data security process in place is something required by the GDPR, and also the documentation of IT security measures. So the data security process means basically that you need to take management measures to protect personal data, and to have this data security process documented in a way that, for example, the data protection authorities are able to control whether your process is done correctly and it is sufficient. On the other hand, the documentation of IT security measures it contains information on confidentiality, integrity, availability, and capacity. And I think I don't need to go into details on how to describe these measures or what measures you need to take. We heard a lot about that in the last 2 days. What I want to stress that is important to document these measures. So to have an internal document in place where you are writing down which measures you are taking, and how you are auditing them, how you are ensuring that they are always up to date. So, coming to the conclusion and some lessons learned, I want to recoup for the last minutes. So basically, we are seeing more and more data protection laws all over the world, and more and more will come, and more will be stronger. Will have more strict views on data protection, and of course, it's not easy as an international company to handle all those different data protection laws. So especially, looking at the GDPR and the APPI, they are really close together, and it's easier to process both of these data than with, for example, the CCPA, because it takes a different approach. So maybe it will be necessary for companies to conduct data audits and to check for which kind of data, which data protection laws will be applicable. Also, ensuring the tagging and documentation of all data within a company will help to identify the data processed in the company, and to ensure that such tagged data is processed by the laws which are applying. When looking at personal data, personal information, or PII, most information on identifiable individuals are covered. And I want to stress again that even pseudonymous data is considered personal data by the GDPR, so it has a really broad approach. with the APPI, probably it will be about the same, while PII, at least up to this point, is not not covering all pseudonymous data. What I skipped today due to time reasons was anonymously processed information. This is something which is included in the APPI, because the GDPR simply says if a data is anonymous, then the GDPR doesn't apply, and in all other cases it applies. The APPI takes, in my point of view, the better approach than the GDPR, because it says in many cases it might be not possible to ensure 100% anonymity of personal data. And in these cases, there are special rules on what to relate to with such anonymously processed information. And this rule in the APPI might help to process data and to use data on an active way regarding data which might be anonymous or at least mostly anonymous. So most laws, most data protection laws in the world include provisions on extraterritorial applicability. Especially, I want to stress at the GDPR the obligation to appoint a representative. So it's not only necessary to comply with all the GDPR rules, but you also should have one representative in the EU to ensure that you can cover these standards. And organizing the processing in a way to avoid the full GDPR responsibility. I already mentioned that. For example, it might make sense to process data by a European company, because then the European company will have to comply with the GDPR, but there are less rules for in Japan or in other third countries. And coming to an end, regarding IT security measures, the GDPR requires not only to document the measures, but also to ensure integrity and availability of the personal data. So thank you very much for listening, and I'm around afterwards. If you have any questions, please contact me.
はい、ありがとうございました。